Good morning to all.
Good morning, sir.
Okay. Today we are going to discuss about our new topic, that is Prime Minister of India, and also we are going to discuss about our Indian judiciary system. In that, we are going to discuss about the structure of the judiciary and the powers and functions of the judiciary. So now we are going to discuss about uh, the Prime Minister of India. Here we are adapted, as we discussed, we are adapted a British parliamentary system. We are applying to that Indian context in the manner of British parliamentary system. So here, as we discussed in previous class, here president is the head of the state and the nominal executive authority. Here, in the sense of reality, prime minister is the head of the government and also the real executive of authority. So the constitutional provisions of prime minister of India, and as we discussed in constitution of India, article 74 75 of part 5 of the constitution deals with the union council of ministers, and also uh, Article 53 says about the executive powers of the President of India. Here, the Prime Minister of India is the real executive of our government. So, here we are going to discuss about in detail about Council of Ministers and also the powers and functions of the Prime Minister of India. Before that, we have to know about the appointment and the eligibility of the selection of the Prime Minister of India. Here, in our Constitution of India, says the Prime Minister of India is the important role. He is having important role in between. We are having a federal structure in the government system. Here, we are adopted federal structure from Canadian constitution, federalism in a region. Here, overall, we are having 29 states and 7 union territories. However, it was equally a unique achievement in terms of constitutional design, which has been under the guardianship of judiciary. So here, the powers of functions of the Prime Minister of India is explaining about the original powers of the Prime Minister of India according to the Constitution of India. So here, India has a parliamentary system of government. In this sense, the entire government is directed by the Prime Minister of India in the name of Prime Minister of India. Originally, executive powers all are maintained in the name of President of India, but in the sense of reality, the exercising of that executive powers are on the hands of the Council of Ministers, which is headed by the Prime Minister of India. Here, in the sense of Indian government structure, we are maintaining a parliamentary and a semi-presidential system we are adopted, because we are having both futures in the implementation of the government system. The Prime Minister is the head of the cabinet too, and also the leader of the Council of Ministers in the executive arm of the government. So, according to the Article 75 of the Constitution, here the President appoints the Prime Minister. And also, Article 74, subclause 1 establishes a Council of Ministers led by the Prime Minister of India, and also to assist and advise the President. Here there are different types of ministers also there in our Indian system. Here there shall be a council of ministers which with the Prime Minister at the head to aid and advise the President, who shall in the exercise of his functions act in accordance with such advice. So according to the Article 75 subclass 3, we are adopted a collective responsibility system. As we discussed in previous class, each minister is responsible for entire the government. Each minister, a single minister also responsible for entire the government or the parliament. So in this article, the council of ministers shall be collectively responsible to the house of the people, because they are directed by the Prime Minister of India, and also they are responsible for the President of India. All the ministers must have the membership in either house of the parliament. He must be a member of Lok Sabha or he must be a member of Rajya Sabha. If any minister has no membership in both houses, in any house at the time of his appointment, he must be get elected to any house within the 6 months of the period. Before that, he can elected as appointed as a minister. In Indian Constitution does not provide any classification of these ministers, but there are 3 categories of ministers, such as number 1 is cabinet ministers, number 2 is ministers of state, and number 3 is deputy ministers. Here in our syllabus, we have mentioned about this. Cabinet ministers is the highest rank of constitute the cabinet. They meet often at the regular intervals under the leadership of the prime minister to take decisions and advice to the president. The most important portfolios like home ministry, defense, finance, railways are given to these ministers. Normally, the senior and experienced ministers are given this cabinet rank. According to the Constitution of India, the selection is on the advice of the Prime Minister appointed by the President of India. He can also change the portfolios. Prime Minister advises to the President of India, then President of India can change the portfolios between these ministers. And number 2 is ministers of state. The next category is ministers of state. These ministers generally work under the cabinet ministers, which means they are assisted to the cabinet ministers. They are appointed for the assistants to give assistance to the cabinet ministers. Sometimes some of the ministers may be given independent charge of portfolio. The independent charge of ministers have all the powers and functions of the cabinet ministers. They can attend cabinet meetings also only when they are invited and when certain issues related to their departments are on the agenda of the meeting. This is the ministers of the state. And number 3 is deputy minister. The deputy ministers also ministers, but they are in lower rank. They are not given independent charge of portfolio, or they are attached to the cabinet ministers or ministers of the state. The deputy ministers do not attend the cabinet ministers. Only cabinet and ministers of the state will attend the cabinet ministers, which is headed by the Prime Minister of India. Prime Minister of India will arrange the meetings, and he is the leader of this Council of Ministers. In addition, there are one more category of ministers who are called Parliamentary Secretaries. However, there are no Parliamentary Secretaries at present time. Here, the Prime Minister of India appointment going according to the Article 75 subclass 1 shall be appointed by the President only. After the general elections, who got the majority party, who selected as a majority party leader, the President will invite a majority party leader to form a government. Then he will appoint as a Prime Minister of India. So after every general elections, the President is the can play a crucial role in the appointment of Prime Minister of India. In such conditions, he can appoint anyone as the Prime Minister who, in his or his opinion, can form the government. According to the Constitution, who got the majority, they may have the right to form the government. For instance, so many times there are changes has been made it means the president has a discretionary power in the appointment of the Prime Minister of India. In so many cases, there are previous leaders changed several issues. Anyway, according to Article 75, subclass 1, the Prime Minister shall be appointed by the President only. The qualifications of the Prime Minister must be, according to the Constitution, the member of either any house of the Parliament, which means he must be a member of Parliament. Means he can be a member of Lok Sabha or a member of Rajya Sabha. But in practice and convention, the Prime Minister belongs to Okay, sorry for the interruption. Here we are discussing about the powers and functions of the Prime Minister. In relation with the Council of Ministers, the Prime Minister enjoys the following powers as a head of the Union Council of Ministers. He recommends persons who can be appointed as a ministers by the President of India, which means the President of India appoints the ministers on the advice of the Prime Minister of India. The President can appoint only those persons as ministers who are recommended by the Prime Minister of India. He allocates and reshuffles, means he can change the various portfolios among the ministers. He can ask a minister to resign or advise the president to dismiss him in a case of difference of opinion. He presides over the meeting of cabinet or council of ministers and influences its decisions. And also he guides, directs, controls, and coordinates the activities of all the ministers. He can bring about the collapse of the Council of Ministers by resigning from the office. Since the Prime Minister stands as the head of the Council of Ministers, the other ministers cannot function when the Prime Minister resigns or dies during the tenure. In other words, the resignation or the death of the incumbent Prime Minister automatically dissolves the Council of Ministers and thereby generates a vacuum. The resignation or death of any other minister, on the other hand, merely creates a vacancy which the Prime Minister may or may not like to fill. In relationship with the President, the Prime Minister enjoys these following powers which relation to the President. He is the principal channel of communication between the President and the Council of Ministers. It is a duty of the Prime Minister to communicate the President. All the decisions are taken by the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation. To furnish such information relating to administration of office of the Union and proposals for the legislation as the President may call for and also he advises the President with regard of the appointment of important officials like Attorney General of India, Comptroller and Auditor General of India, and the Chairman and members of Union Public Service Commission and the Chief Election Commissioner and Election Commissioners, Chairman and members of the Finance Commission. And also in relationship with the Parliament, the Prime Minister plays an important role in the lower house. He is the leader of the lower house, and also in this capacity, he enjoys many powers like he advises the President with regard to summoning or prorogating the sessions of the Parliament. He can recommend dissolutions like Lok Sabha to President at any time. He announces government policies on the floor of the House, and also he has the power to change the portfolios of the ministers as his own wish. So, in addition to these powers, the Prime Minister has various roles. He is the chairman of Planning Commission, which we are calling as Niti Aayog, and also National Development Council, National Integration Council, and also Interstate Council and National Water Resources Council. He is acting as an ex officio chairman of these national councils, and also he plays a significant role in shaping the foreign policy of the country. He plays main role with international relations between the our India with other nations, and also he is the chief spokesman of the union government, and also he is the crisis manager in chief at the political level during emergencies. As a leader of the nation, he meets various sections of the people in different states and receives memorandum from them regarding their problems and so on. He is the leader of the party in power. As we discussed, the majority party leader only act as a Prime Minister of India on the recommendation of the President of India. He is the political head of the services too. Thus, the Prime Minister plays a very significant and highly crucial role in the political and administrative system of the country. Once Dr. B.R. Ambedkar stated that if any functionary under our constitution is to be compared with the US president, he is the Prime Minister and not the President of the Union. Which means the original powers are assigned to the Prime Minister of India is equal to President of United States of America. So if we discuss about this relationship with the President of India, according to the Article 74, the Council of Ministers only appointed by the President of India on the advice of the President of India. So there are some limitations to the power of the Prime Minister also there. Vote of no confidence, when no confidence motion introduced in the Parliament under the parliamentary system of government, the Prime Minister is not performing to the satisfaction of the members of the Parliament and not meeting the aspirations for which he was put there, they could pass a vote of no confidence in him. Under such a situation, the Prime Minister must resign if that no confidence motion passes by the House. The fear of being pushed out of the powers house has a limitation of his powers. So some cases, the party to which Prime Minister belongs has an ideology and policies, manifestos they would like to implement. The Prime Minister can therefore not act outside the policies that the party professes. And also advice from the head of the state. From time to time, the head of the state may advise the Prime Minister on the issue of or the other. He may draw the attention of the Prime Minister to certain pertinent issues confronting the country. In the sense, the head of state serves as a limitation to the Prime Minister. In some cases, public opinion also decides the limitation, the power of the Prime Minister. Like the Prime Minister could be influenced by the public. This may happen when he leads the introduction of a policy that the public thinks is inimical to their interest. Also, the Prime Minister counseling may not want to be in the news for the wrong reasons. In that sense, he is limited by the opinions of the public. In recent times, we have observed regarding agriculture bills. Same happened, that bills introduced by the government of India, and many protests has been led by the leaders, public and opposition leaders. Then the union government withdrawn that bills for some time. Some cases, misuse of power by the Prime Minister also will be happened. The Constitution stated that decision to impose emergency was made by Prime Minister. Some cases, if we take an example of during Indira Gandhi, during 1977, it was a situation happened. At that time, they formed a commission named Shah Commission. At that time, the commission stated that decision to impose emergency was made by the Prime Minister Indira Gandhi alone, without consulting her cabinet colleagues, and was not justified. To check the misuse of the power of Prime Ministers, the Lokpal has been provided the jurisdiction to inquire into allegations of corruption against who is or has been Prime Minister. So the Prime Minister plays a significant and highly crucial role in the political sense and also administrative system of the country. So in this sense, the powers and functions of the Prime Minister as we discussed. So here majority of the powers are exercised by the Prime Minister of India, because all original government powers are vested on the hands of the President of India. So at that time, in democratic nation like India, the Prime Minister plays a very significant and unique role in the democratic way. The Indian Prime Ministers have predominantly come from the Indian National Congress over the independence period. The onset of coalition government has resulted in prime ministers coming from parties other than Indian National Congress. The role of the prime minister has become so significant and crucial that observers like to call it a prime ministerial government. So, in some cases, he plays a dynamic role in economic planning too. The prime minister plays a significant role in economic planning of the country. The first prime minister, Jawaharlal Nehru, constituted the planning commission, which formulated India for 5 years. It was formulated on 15th March 1950. Later, we have changed and replaced with Niti Aayog, which means National Institution for Transforming India, which started functioning from 1st January 2015. The chairperson is Narendra Modi at present. The objectives is to achieve sustainable development goals and to enhance cooperative federalism. So, in many key policy making or relationship with the President of India, and he is also the mediator between Council of Ministers and the President of India. He plays a vital role in exercising these powers according to the Constitution of India. Normally, the President and the Prime Minister have cordial relations, but generally, the President to the Prime Minister and acts on his advice only. There are some instances where presidents conveyed their dissents to the prime ministers. So, in previous president's period, which means, for instance, Dr. Rajendra Prasad, the first president of India, differed with the prime minister Nehru in regard to the Hindu Code Bill. He also opposed the policies on land holdings and state trading in food grains. So, this is the powers and functions of the prime minister. So, as we discussed, he is the majority party leader, and also he maintained dynamics of the party system, and also he has the enormous powers of union government, and also some factors also responsible for the rise of the office of the prime ministers, which like dynamics of party system, rise of charismatic leadership, and populist and attractive policies. In some cases, role of mass media also plays an effective role for the growth of image and personality of the prime minister. And also the prime minister is the leader of the nation. In that capacity, he visits different states, meets different sections of the people, and solves the problems of the people. He represents the nation when he visits other nations. The development of the country depends on the dynamic personality, sincerity, dedication of the prime minister. All these factors lead to the growth of powers of the prime minister. So, the role and importance of the prime ministers for our analysis, we have discussed the account of powers and functions of the prime minister, which clearly brings out the fact that the prime minister enjoys the most important, powerful office in the Indian political system. So, some cases, the prime minister in general, there have been more than 14 prime ministers so far Their way of functioning was different. They belonged to different political parties, and the problems they encountered were different. Jawaharlal Nehru, who was the first prime minister from 1947 to 1964, played a most key role, not only at center but also at the state levels. He enjoyed unchallenged authority like unrevealed leader, and also he said to have acted in a most democratic manner. Next, Lal Bahadur Shastri, who also prime minister between 1964 to 66, is described as an effective and strong leader of the nation. Indira Gandhi later between the period of 1966 to 1977 and again 1980 to 84 began with a low profile. However, several strong decisions and effective leadership during 1971 war with Pakistan made her a strong and dynamic leader. At the time of emergence of Bangladesh during the national emergency between 1971 to 1975, she gave a death blow to the pluralistic structure and internal democracy in the party. She acted more or less than a dictator. In other words, all the powers were centralized during his regime. Later, Morarji Desai, Rajiv Gandhi, and VP Singh, thereafter Chandrasekhar, PV Narasimha Rao, HD Devagowda have played different unique roles in their tenure. I.K. Gujral also given a relatively better account to himself during 97 to 98. Later, Atal Bihari Vajpayee between 96 to 98 to 2004 proved his merits during Kargil War. And also, Dr. Manmohan Singh was the prime minister during 2004 to 2014. He was the first prime minister who led the prime ministership 2 times. He played his role in an honest, an effective and sincere way. Unfortunately, he became very weak due to serious causes of corruption against the government. He could not become strong and effective and bold prime minister. Now, Narendra Modi, who is the present prime minister, is said to have proved himself effective and powerful leader in government and as well as in the masses. He remarked as taking strong and effective decisions which are likely to give high-level success. In this way, the prime minister plays an important role of the government. Finally, the role of the prime minister ultimately depends on his experience, charisma, sincerity, quality of his ministers, support from his ministers, from party and the civil servants. Also, should public support should be there. In this scheme of parliamentary system of the government provided by the Constitution of India, the Prime Minister is the real executive authority. This is the powers and functions of the Prime Minister of India. We are also having Indian judicial system. In this Indian judicial system, we have independent judicial system. The Constitution of India provides for an independent judiciary, which means the judiciary is independent of the executive and legislative branches of government. Now, the executive and legislature of the government should not interfere with the decisions of the judiciary. That means we will call it as an independent judiciary. We have 3 branches of the government. One is executive, one is legislature, another one is judiciary. So the judiciary is an independent body. The judiciary is not financially dependent, but the executive or legislature is different from the judiciary system. So here in Indian judiciary system, the judiciary is that branch of the government that interprets the law and settles disputes between the administers justice to the all the citizens. The judiciary is considered the watchdog of democracy and also the guardian of the constitution. Here the Supreme Court is placed as a guardian of the Constitution. For democracy to function effectively, it is imperative to have an impartial and independent judiciary. Here we are having an independent judiciary system for Indian state. It means that the other branches of the government, namely the executive and legislature, does not interfere with the activities of the judiciary system. So it also means the judges can perform their duties without fear and favor. They will act independently. According to the Constitution, the other organs like legislature and executive cannot enter into the activities of the judiciary system. So the Constitution provides for a number of provisions that ensure that the independence of the judiciary is maintained and protected. For more, many reforms also there, many provisions also there in our Constitution. India has a single integrated judicial system. The judiciary in India has a pyramidal structure with the Supreme Court at the top and high courts are the below to the Supreme Court of India. And below them are the some district courts also there, and also subordinate courts also there. The lower courts function under the direct superintendence of the high courts. So we have at the top level Supreme Court of India, then High Court, then District Court. To assist to District Court, there are subordinate courts. So apart from this structure of the court system, there are two branches of legal system. One is criminal law and another one is civil law. Criminal law deals with the committing a crime by any citizen or entity. A criminal case starts when the local police file a crime report. The court finally decides on the matter. For civil law, deal with disputes over the violation of the fundamental rights of the citizen. As we discussed in fundamental rights chapter, the Supreme Court and High Court has the special authority for the protection of the fundamental rights of the citizen. As we discussed, there are under Article 32, there are 5 writs are there like habeas corpus, mandamus, prohibition, certiorari, and quo warranto. These writs will issued by the higher courts like Supreme Court and High Court. So if we discuss about the structure of the Supreme Court, we have established this Supreme Court before the independence. We will call it as a federal court. We will call it as federal court after implementation of the Constitution of India. That federal court renamed with Supreme Court of India and came into existence on the 28th January 1950. Before that, according to the Regulating Act of 1773, the Supreme Court has been tracked back by this act. And also at present, according to the Part 5 of the Constitution of India, from Article 124 to 147 deal with the composition, powers and functions of the Supreme Court. Now, the Supreme Court is located in New Delhi. It is the highest judicial authority of India. It is in fact one of the most powerful courts of the in the world. Supreme Court of India came into existence after the implementation of the Constitution of India. So if we discuss about the composition of the Supreme Court, the Supreme Court presently it comprises the Chief Justice plus 24 judges. So appointment and qualifications also there in our Constitution. As per the Indian Constitution, the President appoints the Chief Justice of India in consultation with such judges of the Supreme Court and the High Courts as the President thinks proper. The other judges of Supreme Court and High Court are appointed by the President after consulting to the Chief Justice of India. So since 1999, the judges are being appointed by the President only on the recommendations of the Collegium of the Supreme Court. Collegium means it is organized by the senior most judges of the Supreme Court. This is a team headed by the Chief Justice of India and the foremost senior associate judges of the court. Its recommendations are binding on the President. So if we discuss about the tenure of these judges, once appointed as the Chief Justice of India or other judges of the Supreme Court holds office until 65 years. A judge may voluntarily resign before expiry of his term. A judge of Supreme Court or High Court may, however, be removed on the ground of proven misbehavior or incapacity. The President may remove Supreme Court judges by the impeachment procedure laid out in the Constitution. According to this procedure, each house of the Parliament will have to pass a resolution supported by the 2/3 majority of members at present and voting. One such instance was Supreme Court Justice V. Ramaswamy's resignations in 1991, following a committee report of gross misuse of the official position by him and subsequent impeachment procedure in the Parliament. We can therefore say that while the Supreme Court judges are appointed by the President, they hold office only on the grounds of good behavior. After retirement, however, the judges cannot practice in any court of law. For salaries, the judges of Supreme Court of India are paid. Such salaries are determined by the Parliament from time to time. In other words, judges' salaries and other allowances cannot be voted by the Parliament and state assemblies. They are fixed high in order to secure their independence, efficiency, and impartiality. As per the High Court and Supreme Court Judges Amendment Bill 2017, the salary of Chief Justice of India is 2.8 lakh per month. The salary of judges of Supreme Court and Chief Justice of High Courts are fixed at 2.50 lakh per month. The judges of High Court draw a monthly salary of 2.25 lakh per month. Besides this salary, every judge is entitled to a rent-free official accommodation. The administrative expenses of the Supreme Court, the salaries and allowances of the judges are charged on the consolidated fund of the India. So this is the structure of the Supreme Court. If we discuss about the powers and functions of the Supreme Court, the Supreme Court has a important role in the functioning of their powers. So the Supreme Court is one of the very powerful courts in the world. Article 141 provides that the law laid down by the Supreme Court shall be binding on all courts within the territory of India. According to the Constitution of India, the Supreme Court of India categorized into three parts: as a federal court, as a court of appeal, as a guardian of the Constitution. All these powers are explained through different jurisdictions vested in with the Supreme Court. So the Supreme Court has three types of jurisdictions, namely, number one is original, number two is appellate, number three is advisory. For original jurisdictions means all such cases begin and originate in the Supreme Court only. It also means that such cases cannot be initiated in any other court. According to the Article 131 of the Constitution of India, the Supreme Court is vested with original jurisdiction. And also, as a federal court, the cases or disputes that come under its original jurisdictions are: number one is disputes between the government of India on the one side and one or more states on the other side, which means disputes between the state and center. are some states and the center. Like in such cases, like water disputes or boundary disputes or any administrative issues, at that time the Supreme Court will act as with this original jurisdiction. In second case, disputes between government of India and one or more states on one side and one or more states on the other sides. And in third case, disputes between two or more states. At that time, this Supreme Court will place a crucial role to solve these issues. It serves as an arbitrator for final settlement of disputes between these uh, parties. So such disputes must, however, involve some question of law. For example, the dispute between the sharing of river water or natural resources between the two states in India can be directly brought to the Supreme Court under exercise of original jurisdiction. For second one, appellate jurisdiction means a citizen can appeal to the Supreme Court against any judgment, decree, or final order of a Supreme Court. Both in civil and criminal cases, he can approach the Supreme Court. If one of the parties to a dispute is not satisfied with the decision of High Court, one can go to the Supreme Court and file an appeal. The Supreme Court will then reconsider the case and the legal issues involved in it. The Supreme Court is the final court of appeal. The Supreme Court hears appeals from all courts in India, and it has vast appellate jurisdiction in cases involving civil, criminal, and constitutional cases too. Disputes relating to property, marriage, money, contract, and service, etc., are related called as civil cases. In criminal cases, if the lower court has sentenced a person to death, then an appeal can be made to the High Court or Supreme Court. Appeals in constitutional case means cases arising out of different interpretations of constitutions, mainly regarding the fundamental rights. In such constitutional cases, an appeal can be taken for the Supreme Court only if a High Court denies a certificate of fitness to appeal to the Supreme Court. However, the Supreme Court holds the power to decide whether to admit appeals even when appeal is not allowed by the High Court. For third jurisdiction of advisory jurisdiction, the Supreme Court of India also possesses advisory jurisdiction. Under Article 143 of the Constitution, the President of India can refer any matter that is of a public importance or that which involves interpretation of the Constitution to Supreme Court for advice. However, the President is not bound to accept such an advice. He may follow or he may not follow. Then what is the utility of the advisory powers of the Supreme Court? The utility is twofold. Firstly, it allows the government to seek legal opinion on the matter of importance before taking action on it. This may prevent unnecessary litigations later. Secondly, basing on the Supreme Court advice, the government can make suitable changes in its actions and legislations. So, the Supreme Court has non-exclusive original jurisdiction such as a review jurisdiction. This means Supreme Court has the power to review its own judgment or order. If the Supreme Court discovers that some mistake or error took place in its previous decision, it has the power to review the case and alter its previous decisions. This is generally done when a review petition is filed. The Supreme Court utilized this power in the Keshavananda Bharati case in 1973 and reversed its judgment in the Golaknath case 1967. However, this power is subject to laws made by the Parliament or rules made by the Supreme Court. And also, despite these powers, the Indian Supreme Court is the product of the Constitution of India and depends on the continuation of these powers on the Union legislature, which can impose limitations on them by amending the Constitution. Moreover, all the powers can also be suspended or superseded whenever there is a declaration of emergency in the country. And also, it is act as a court of record. Besides the original appellate and advisory jurisdiction, the Supreme Court of India possesses a few miscellaneous powers. According to the Article 129 of the Constitution, makes the Supreme Court as a court of record. All the judgments, all the decisions, and all the proceedings of the Supreme Court are kept as records and archived. All its decisions and judgments are quoted as precedents in all courts of the country. As a court of record, the Supreme Court has the power to punish individuals for contempt of the court. For high courts also plays an important role in the state. Part 6, Chapter 5 of the Indian Constitution provides for a high court at the apex of state judiciary, like Supreme Court for union government or for entire India. For high courts are there for the state judiciary system. High courts have jurisdiction over a state or a union territory or a group of states. They work under the Supreme Court of India. At present, there are 24 high courts are there in states of India and the union territories. The parliament has the power to establish a common high court for 2 or more states. For instance, Punjab and Haryana and the union territory of Chandigarh have a common high court. Similarly, the High Court of Assam located in Guwahati is common for 7 northeastern states of Assam, Nagaland, Manipur, Meghalaya, Mizoram, Tripura and Arunachal Pradesh. So, the composition of High Court is every High Court has a Chief Justice and a number of judges. The number of judges varies from state to state. The president from time to time will determine the number of the judges of each High Court. For appointment of and qualifications of High Court judges, the judges of High Courts are appointed by the President of India as per the recommendations of the Collegium of Supreme Court. While appointing Chief Justice of a High Court, the President has to consult Chief Justice of the Supreme Court and the Governor of the state concerned. While appointing other judges, President consults the Chief Justice of the Supreme Court and the Chief Justice of the High Court and Governor of the state concerned. So, for powers of the High Court also has original appellate powers. For original powers under these original jurisdictions, the High Courts have to power to hear and decide cases which are brought directly to it. The High Courts have the power to issue directions, orders, writs similar to the Supreme Court and also hear PIL cases. PIL means public interest litigation. Cases of alleged violation of fundamental rights can be started in High Courts. Petitions challenging the election of a member of parliament or member of legislative assembly or local body can be filed in the High Court. It can set aside a election of a member if it finds that he used corrupt means in his election. For appellate jurisdiction of High Court, a High Court is mostly a court of appeal. Appeals in both civil and criminal cases are brought to High Courts against the judgments of the subordinate courts. So, it's also act as a court of record like Supreme Court. The High Court is also a court of record. Lower courts in a state are bound to follow the directions of the High Court, which are cited as precedents. The High Court also has the power to punish for its contempt or disrespect. This is the functions and powers of the High Court. And also we have one important provision about judicial review. Judicial review means the power of the Supreme Court to examine whether the law enacted by a legislature, in case parliament or state assembly, or an action of the executive means presidential order is in accordance with the constitution or not. If it finds violation of any provision of the constitution, the Supreme Court may declare that concerned law as ultra vires, which means they can review, the High Court or Supreme Court can review the concerned law and suggest the executive or legislature to modify that law. So that is the special authority of the higher courts. The review power means that the judiciary can interpret the constitution and the laws passed by the legislature. Indian constitution has designed the Supreme Court to be the final authority on the interpretation of the constitutional provisions. For judicial review is thus an important guarantee of rights of the people, as the Supreme Court does not allow any violation of the constitutional provisions. So, in fact, it has given several new interpretations to the constitutional provisions. It is on the basis of this power of the Supreme Court called guardian of the Constitution. So, many controversies also there in the selection of the judges about regarding collegium system. Many recent issues in the Supreme Court also there regarding selection of the Supreme Court judges. So no judge can take upon the matter of his own unless allocated by the Chief Justice of India. So the allocation of cases is completely in the hands of the Chief Justice of India. So they are misusing the power. They are allocating cases to their near and dear judges. So the controversy has emerged in the Supreme Court over the absolute power of the Chief Justice on the judicial administration too. So many cases, courts are the plays important role for the protection of the Constitution of India and also protection of the individual rights and liberties of the citizens who are living in the country. So without judiciary system, the administration cannot follow the Constitution of India. That's what we are calling as Supreme Court is the guardian of the Constitution. So this is our today's syllabus. In next class, we are going to discuss about the state government. In that chapter, we have the syllabus of state legislature, composition and powers and functions, and governor, chief minister, and council of ministers. Thank you. Thank you for your participation.
Sir, President powers kinda formation of Council of Ministers anundi sir. అందులో he decides the proportionate strength of the ministers from each house of the parliament anundi sir. అదే ఏంటి సార్ అది?
ఎక్కడ ఉంది అది?
ఫార్మేషన్ ఆఫ్ ఇవాల్టిదే సార్, పవర్స్ అండ్ ఫంక్షన్స్ ఆఫ్ ప్రైమ్ మినిస్టర్.
ఎక్కడ ఉంది పవర్స్ అండ్ ఫంక్షన్స్ లో? ఫార్మేషన్ ఆఫ్
కౌన్సిల్ ఆఫ్ మినిస్టర్స్.
ఓకే. అయితే ఎంతమందిని ఎంత అంటే ఒరిజినల్ స్ట్రెంత్ లో 15% మించకుండా మినిస్టర్స్ కి పోర్ట్ఫోలియోస్ ఇవ్వాలని మనకు కాన్స్టిట్యూషన్ చెప్తుంది.
అంటే ప్రొపోర్షనేట్ స్ట్రెంత్
ఈచ్ హౌస్ అంటే ఓవరాల్ గా రెండింటికి కలిపి 15% అని దాని అర్థం. ఇప్పుడు ఏం చేస్తారంటే వాళ్ళకు ఇష్టమైనంత ఇవ్వడానికి వీలు లేదని మనం 2003లో 91 కాన్స్టిట్యూషనల్ అమెండ్మెంట్ యాక్ట్ తీసుకొచ్చి దాన్ని 15% కి రెడ్యూస్ చేయడం జరిగింది. లేదంటే వాళ్ళకి తెలిసిన బంధువులకు వాళ్ళకి వీళ్ళకి ఎక్కువ మందికి పోర్ట్ఫోలియోస్ ఇచ్చి పవర్ ని మిస్యూజ్ చేస్తారన్న ఉద్దేశంతో దాన్ని లిమిట్ చేశారు అన్నట్టు.
ఓకే సార్. ఇంకొకటి మెంబర్స్ ఆఫ్ WPSC అంటే ఏంటి సార్? WPSC అంటే
ఎక్కడుంది డబ్ల్యూపిఎస్సి అని?
పవర్స్ ఆఫ్ అపాయింట్మెంట్ ఆఫ్ ప్రైమ్ మినిస్టర్ కింద ఉంది సార్.
టెక్స్ట్ బుక్ లోనే ఉందా?
లేదు సార్, నా దగ్గర బుక్ లేదు, మీరు ఇచ్చిన PDF మాత్రమే ఉంది సార్. అది ఓకే సార్, రెండు చెక్ చేయలేక నేను పక్కన బుక్ చెక్ చేస్తున్నాను సార్.
ఇక్కడ పవర్స్ అండ్
పవర్స్ ఆఫ్ అపాయింట్మెంట్ ఆఫ్ ప్రైమ్ మినిస్టర్ కింద గవర్నర్స్, అంబాసిడర్స్, జడ్జెస్, చైర్మన్ అండ్ మెంబర్స్ ఆఫ్ WPSC అని ఉంది సార్.
పేజ్ నెంబర్ ఐడియా ఉందా?
లేదు సార్.
నెక్స్ట్ క్లాస్ లో నేను చూసి చెప్తాలే.
ఓకే సార్.
ఓకే, థ్యాంక్ యూ.